For proper understanding of the constructive trust, I take you to the Civil Procedure Code, and you must have read under Civil Procedure Code section 11, which talks about res judicata. Although it is not, the constructive trust does not mean that this is similar to that res judicata, but it will be easier for us to understand what is the constructive trust. So for that, we first have to understand what is constructive res judicata. And it is almost same. Res judicata is in section 11, and there is another term which is used in explanation 4 of section 11, that is constructive res judicata. That constructive res judicata is constructive trust. To understand the constructive res judicata, we have to understand what is res judicata. Yes, please, anybody of you, what is res judicata? What do you understand by res judicata? Res judicata means whenever a case or the we should not say case, whenever the civil suit, whenever suit of the same subject matter between the same parties decided by the competent court, that suit cannot be brought in the court again in future. It is about the finality of the judgment of the court, civil court. If there is a suit which is between the same party, by the competent court, means the court must have the jurisdiction to decide that suit. Again, the suit cannot be brought for that subject matter in future. That is final, right? What is constructive res judicata? What happens so many times, that knowingly or unknowingly, intentionally or unintentionally, sometimes some essential issues are left to mention in the suit. Res judicata means that a certain issue or issues have been decided by the court and they are final. But what happens sometime, and it may be in bona fide belief, that the parties in the suit may not have mentioned certain essential issues which were essential in earlier suit. Now the question is, and when the essential issues were not mentioned, so what the party did? Party again came before the civil court with that essential issue and argues before the court that this was very much essential issue for this suit which we left to be mentioned in earlier suit, therefore we should be heard now or we should be heard again. And we know what is the res judicata. Res judicata means where if the issues have been decided earlier between the same parties by the competent court of the same subject matter, that cannot be decided again in future. What will be done now? If the party again come to the court, this is constructive res judicata. Constructive res judicata means the court will say, or it is given in explanation for that if an issue should have been raised in earlier suit, it shall be considered by the court that it was raised. If an issue for any reason whatsoever could not be raised in former suit, in earlier suit, and the matter comes before the civil court, in that case the court shall consider about those issues which were not raised in earlier issues, that all these issues have already been raised earlier, though in fact in reality they were not raised. So this is the constructive res judicata. Got it? It is constructive res judicata. The court shall consider. It is altogether different thing. You have not raised those issues, but the court shall consider that. Okay, court assume that these issues were raised already. In the like manner, there are certain situations, circumstances, which says that directly, it does not come from those circumstances that it is a trust, but the circumstances are like that, it is considered by the court of equity that it is a trust by virtue of constructive trust. It is for actually inequitable accusation of another property. If there are the instances of inequitable accusation of another property, in that situation, the constructive res judicata comes in to protect that property. Directly, we don't have any provision in our act with regard to the constructive res judicata, but section 79 to 82, there are certain instances which are similar to constructive res judicata. And basically, these things were of court of equity. because entire trust law has come from the Code of Equity. Okay. The last one is resulting trust. What happens in resulting trust? Whenever a trust is created and the trust is distributed, so there are sometimes many instances that after the distribution of the property of the trust, some property is left out. The object of the trust is fulfilled, but even then certain property is left out. Now the question is, what is to be done to that property? Where should it go? Should it be again distributed among the beneficiaries? For example, the trust is created for, suppose, 10 rupees. There are three beneficiaries. Each beneficiary will get 10 rupees. Okay. And after distributing the 10 rupees, the 12 rupees are left out. Or we can say that it is total amount is of 42 rupees. So where the 12 rupees will go? Should they again be distributed among the beneficiaries? Each will get 4 rupees, or should it go to author of the trust? So if there are such a trust, for example, a trust is created for the benefit of certain people, hmm, and the object is fulfilled, it is just an example because trust is created for so many things. It is not always for cash money. There are number of things, number of every type of property is there. What happens in the resulting trust? After fulfilling the object of the trust money is given back to the author of the trust. It is resulted to the truster. It is resulted to the author of the trust. It comes back to the author of the trust. It is resulting trust. After equal distribution of the property among the beneficiaries, whatever is left out, that is given back to the author of the trust. It is resulting trust. It was a brief about the kinds of trust. Anything you would like to